Welcome to the Meaningful Mediation Podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. All right. Well, welcome back to the Meaningful Mediation Podcast. This is the show where we talk with the lawyers, mediators, and negotiators who spend their careers doing the hard work of negotiating. Today, my guest is someone whose practice doesn't fit neatly in one box. So Giacomo Bossa is a partner at Barakat Bossa here in Miami. He is board certified by the Florida Bar in both business, litigation, and real estate. He's also fluent in Italian and Spanish and admitted in 3 states and before the U.S. Supreme Court. He tries cases to verdict, runs international arbitrations, and structures cross-border deals, which means he negotiates from just about every chair at the table. Giacomo, welcome to the show.
Thank you, Patrick. That was a lovely introduction.
Thank you for being here. And before we get into the bigger questions, I wanted to start where most listeners will start, with how you ended up doing the work you do. What's your journey?
So my journey started a long time ago and a place far away. It sounds like the beginning of a magical story, but it isn't. I was born somewhere else. I was born in Rome, Italy. And I guess I was fortunate enough to be born in such a place. And as a young kid, I had parents who were very, for lack of a better word, intellectual. My parents were not much into sports. They were into the arts, the music, and every dinner, every night, without fault, will be a debate of whatever it was that was going on during that day. And I think that I just naturally developed an ability to engage in meaningful conversations. And I suspect that as it happens with a lot of kids that have that tendency, people around me started saying, you should be a lawyer one day. You act like a lawyer, you behave like a lawyer, you're a lawyer. And of course, it gets to you. It gets to your head. And so I think I gave it, some weight. I started thinking that was the path that was going to be in front of me. And then I graduated high school. And high school was, in the way it works in Italy, it's interesting. I'll take a minute to give you that distinction. There's 2 main high schools. One is what we call the classical high school. You'll study more Greek and Latin, less math and physics. And then there is the scientific high school. There's no Greek, there's a little less Latin. You'll do a lot more math and some hardcore physics. And the one I decided to go to was a hyper scientific one. They even included some coding that you'll do in high school. So in a sense, inconsistent with the idea of becoming a lawyer, because you will think that you'll go study all the languages of those who first created the concept of rights. But to me, it was only natural because I only saw the law as an algorithm, right? As a set of rules that you have to apply and succeed in applying in a certain way. And when I had to pick right out of high school. You don't go to college overseas. In most places, law school is an option, just like every other major that you'll get. It's 5 years though, so it's very long, but you have to pick when you're 18. So when I was 18, I had to make that decision, and I was in between law school and physics, because I thought one is the set of laws that regulate human behavior. The other one is the set of laws that regulate sort of everything else, the way we interact with the rest of the world. And I ended up picking law school, quite obviously. But that's not to say that one day, if I get exhausted, maybe I'll change my mind and I'll go back to physics.
Okay. Very interesting. So you came to law through an unusual path. And I note here that you went to undergrad in Brussels. Is that correct?
So no, that's another quirk being European. When I went to law school, within Europe, there's a program that's an exchange program that's facilitated. It's a lot easier to go study abroad. You don't really have to do a lot of paperwork. There's a bunch of colleges or law schools, in this case, that have agreed in advance to receive some students that will take some courses, and then those courses will be recognized. So you don't do it during the summer. You do it during your regular semester. And so before coming to America, and I'm sure we'll talk about that in a minute, before that, I went to Brussels. And I went to Brussels because I always wanted to be able to practice law in a language that wasn't my own, right? So I always wanted some international exposure. And at the time, even now, although now there's certainly more criticism that can be validly addressed to the European Union, at the time, Brussels was the place where you were really dealing with all the cohesive uh, laws and regulations that were being applied uniformly across different states. It was a very fascinating process to witness.
And did you then partake in some law courses, not only in Italy, but also in Spain?
Yeah, so that was something else. When I guess when I first graduated law school here in the US, or as I was in law school, I can't remember, I decided that I wasn't going to become a lawyer in Italy, because there's a much longer wait period and it's a little bit of a painful process. And not for nothing, the taxation of the profession in Italy doesn't make a whole lot of sense. But I had an option to get my law degree recognized as a law degree in Spain. And so I did that. I had to study on my own, sort of some of the baseline Spanish law classes. And then I went and I took an equivalence exam that recognized that my law degree in Italy is now also a law degree in Spain, because I have all the sufficient knowledge to do that. So I did that at some point randomly. I still remember flying over to this island and then spending a few days there to take the exam in Spanish. It was quite an adventure.
Sounds like it. And then what about law at Nova?
Right. So that's how I ended up in the US. So I was really lucky. There's a joke between me and one of my she's no longer my paralegal, but the joke goes that I wanted to write a book called Luck as a Survival Strategy. And that has generally been the way I've approached things. I think that it's gonna go well, and it's fine. It's just gonna go well. We can take luck into account as we go do things, because we're gonna get some level of it. And so I joined my law school in Rome, and there was no program to move over to the US. But I think a year into my law school, they signed an agreement, my law school in Rome and Nova Southeastern University in Fort Lauderdale. And that agreement was to have students from both places go and get a dual degree in the other place. So if you were from Rome, you'll be able to get a dual degree from Nova. If you were from Nova, you'll be able to get a dual degree from Rome. And of course, it required a lot of time. You had to spend the same amount of time, or approximately the same amount of time. There was a small amount of credit recognition in the program. And so you had to go to law school twice, in a sense. But it was facilitated, right? There was a lot of support. There was no LSAT you had to take. You had to take a separate entrance exam. And I was like, yes, this looks like my dream. And I want to do that. So there was a little entrance exam. I applied for that. I did very well on that. And then I moved to the US, and I sort of never looked back.
And your approach with all these different countries and your belief system of being basically cross-disciplinary has carried over to the way you practice law now, right?
I think it's absolutely true. I think that is correct. I have resisted the modern urge to hyper specialize. Now, I have done it within a realm which is business law. Right? At the end of the day, and not even call it business law. It is the idea of the law that regulates money making as an activity, right? deal law, if you would. But I had decided that I didn't want to go hyper specialized because I suffer from a disease that when I go and hyper specialize, I get bored of whatever it is and I move on to the next thing. And if I can keep myself sort of forcing constantly to jump from one thing to the other, first, I won't get bored of whatever it is that I'm doing because there's a lot to learn. And then something magical happens. You start taking this piece of information from down here and move it over here where nobody has ever thought about it. It doesn't make sense because it's not part of the funnel that everybody else has been traveling on there. But you say, but wait a second, why can't we do that? And I think that that has served me well in my sort of dual function as a lawyer, but also a law firm owner, somebody that has to grow and move forward the law firm in positioning and servicing clients throughout the space.
And you've handled high stakes international disputes where perhaps your counterparts are on the other side, maybe sitting in a different country. They may be speaking a different language. They may have different legal training. How do you build trust in that kind of a negotiation?
So I'll confess that it's a lot easier for me to build that trust than it is for most people because I was very lucky that I have been exposed to, I would say, at least three of the macro continents in a way that's not just it's a cultural exposure that has seeped in from familial, personal, or working relationships. So I was born overseas and I was exposed to Europe and a bunch of different options in Europe. I came to America, went to Fort Lauderdale, then moved down to Miami. Miami, as we know, has a uniqueness in the US, which is this great exposure to LATAM. And I was married for a while to a wonderful gal, and she was from Venezuela. So there was certainly a lot of exposure culturally, emotionally to the political developments of Venezuela and the political developments of the rest of Latam. And my most of my friends down here are from Argentina or from Colombia, and I am in hopefully for a very long time in a relationship with a Colombian, and so I am able to immediately connect across the aisle with the other person because I have been where they are now, and I remember. I remember the pain, I remember the struggle, I remember the challenges. And because I remember and I understand, I can sort of reach across the aisle in a way that's a little different. I get immediate trust back if I don't screw it up. And I don't get perceived as condescending, I think, generally speaking, but helpful. And that has really changed my career.
And that's such a unique asset and skill to have, because I would say that most lawyers, at least those here in the States, don't have that type of a background. And you're one of the few people I know that you can cross 3 different places and you feel comfortable in all 3 sandboxes.
It wasn't intentional. It really it wasn't planned, right? It took me a while to realize that it had happened, and
Mhm.
I can confess to you weakness. I remember the first time that I did my first hearing. It was a motion to withdraw, and most lawyers know that that is hyper straightforward nowadays. You show up, you say that there are some problems with the clients, and you want to withdraw. But it was my first hearing ever. And I was convinced, Patrick, that I was just not going to remember how to speak English, that everything was going to disappear from my brain, and I was going to stand up in front of the judge completely muted, unable to produce a sound that will make any sense. And so I remember that fear. I do. I remember that fear. I remember that discomfort. And I don't know that at the time I was intelligent or intentional or wise enough to understand that will become over time an advantage. It took me a long time to accept that it was an advantage. It really required a shift in the way I was thinking.
Yes. And I wanna approach that shift from a different angle. So, on the transactional side, you negotiate corporate deals and real estate transactions where perhaps your job is to anticipate risk or resolve issues. But how do you bring a litigator's eye to that deal without killing it? So that's something that's separate in our brains, right? You have the negotiation side and you got the litigator side.
Um, I this one I don't know that I have ever truly struggled with. I think it was natural to me because the way I litigate is maybe a little different. I like litigating business disputes, deals, because my objective is a deal. And I don't look at that a lot different than a negotiation. Now, the difference is that I am gonna position myself in the litigation through litigation strategy and very aggressive, intelligent moves that are going to put my client in a favorable position to achieve the business goal. And in the sort of deal making, you're doing the same thing. You can't reposition through a third party. A judge is going to say, you did this well, so you're getting disadvantage. You can't do that. But you can reposition through sort of knowledge and reasoning and correct assessment of what's happening. I recently was involved in a very fascinating bankruptcy. I don't do bankruptcy normally, but in this case, my client needed bankruptcy as a solution to a unique litigation problem. It was a mass litigation. So I brought on board bankruptcy counsel. And at some point in the negotiation, I used the request of the other side against the other side because I said, the only way I can give you this and for it to make sense for me is if this other thing happens, because if it doesn't happen, then my incentives are misaligned. I give you this, and then I also suffer a damage on the other end because you're not giving me this other thing. And this was really what we needed. It was really a key component of the structure of the solution for the client, a structure of a solution that we were not able to achieve in bankruptcy per se. We couldn't. But that was really just a deal. It really was just a deal. It was no more litigation. It was about, where are my drivers? Where are your drivers? Can I explain to you that this driver is inconsistent with this driver, but if we modify the routing, then these two drivers get aligned together. And so I don't suffer the sort of, I have to change personality now. I have the same personality that I normally have. I always, I'll tell you something that most people find funny. I don't think I'm confrontational. I think I am not very confrontational. But people sometimes think I'm very aggressive. And I don't know that they think I'm antagonistic, but I certainly have a strong personality and strong opinions and a strong belief in, when I believe something is accurate, I believe that's accurate, but I'm not confrontational. And so I'm not really changing hat when I negotiate a deal.
Very good. So I wanna slow down just for a second and ask you about one specific case. Of course, you're not gonna name it, but because I think that's where the real lessons live. So looking back across everything you've handled, whether it's trials, arbitrations, or deals, there's usually one that changes how a lawyer thinks about the work. Tell me about that one for you. Like, what happened? What did it teach you about negotiation that perhaps you couldn't have learned any other way?
So I am going to start with giving you an answer that's not, and I hope you'll forgive me, Patrick. It's not exactly responsive to your question. It is almost entirely responsive, but it is an answer that's dear to me, and it's a subject that I take a lot of pride in talking about. And it's the case where I met my business partner, Brian. I met Brian as a very young lawyer. I think it was in 2013, and I graduated law school 2012. So I'd been out of law school for about a year. It was a federal case where I represented the holder of a note, a foreign individual, and I sued the borrower under that note, who was represented by Brian. And I remember a number of things that happened in that case. I remember that there were moments where I was overly aggressive because I didn't know how to channel the strength of my argument in a different way. And I remember Brian not getting mad at me. I remember Brian not getting offended, Brian understanding that was a limitation of my training and skills at the time, and it wasn't a reflection of my persona. I remember doing this at some point at a hearing, and the judge understanding that I was right on the merits and the sort of passion with which I was exposing the argument was a limitation on my wiseness at the time. And this case is the case through which I met Brian. We litigated for about a year. We became friends. He became my mentor after the case. He really helped me throughout the rest of my career. I was at a very small firm prior to that. And so it was very helpful to have one friend outside the firm that I could call and say, what do you think about this? What do you think about that? And then eventually later on, I was ready to sort of combine forces with him. And we ended up doing that. But we ended up doing that after the clients in that case ended up settling the case. Many, many, many years after the final judgment. And there were some pressure points in that case. They were not monetary per se, because Brian's client had eventually left the country. And the only thing that I could do was to create more pressure. And at the time, there was not Zoom. There wasn't any sort of real means of doing stuff online. And I told the judge, I want him here. I want to interview him here. I want him in person, and you should force him to do it. And if he doesn't do it, you shouldn't give me any monetary value. I already have a judgment for whatever I have. It doesn't matter. Money doesn't matter to him. You should enter a writ of bodily attachment, because the only thing that's going to matter is that. And it's hard to get one of those, and it's harder to get them in federal court, but I got it. And so many, many years later, before Brian and I actually merged, there was this new negotiation, because the gentleman on the other side wanted to come back, but he had a writ of bodily attachment waiting for him. And so there was a negotiation at the time. I think that a lot of the personal heat was gone by then, right? As we all know, as I'm sure you know better than I do, time is the best driver of negotiations, right? Because if there are emotions that take over, time will remove them eventually. And so it was much easier to negotiate that deal. The deal was negotiated, and sort of as a coronation of that, I don't know if it was a few years or a few months later, Brian and I ended up merging together.
Well, I think that was spot on. That was a case that certainly propelled you onto a different path. And there was a lot of introspective learning that went along with it as well. So excellent. So that's a good place to land before we get into what I call the mediation toolbox. All right. So this is the part of the show where I ask everyone to give me a couple tools that they keep in their toolbox that they like to use during mediation. So when you walk into, let's say, a mediation there's a serious settlement negotiation, what's the one tool, habit, framework, or move that you reach for almost every time?
Okay. So my sort of go-to approach is to make sure that I understand if there's a space for a win-win situation that nobody's thought about. It happens more often than people outside of what we do will think, because we get so caught into the fight that we forget to look at it and say, is there a business solution that's creative, maybe that's outside of what we're looking at, but that achieves what you need and what I need? Is there a win-win? And maybe that's a privilege, Patrick, of dealing with deal law. You don't get that benefit. Maybe if you are working in a different type, I don't know, if you're working in personal injury, maybe there's less opportunities for that, I suspect. If you're dealing with family, maybe there's less opportunities for that. I don't know. But we deal with people trying to make money all the time. And ideally, we want everybody to make money. And there's something that has happened that has prevented one or two or three or everybody from making money, right? And so often you have to ask, is there a way that we can all go back to making money? And maybe that's a way that doesn't get you the maximum amount possible of making money, but it gets you money, and it gets me also money, whereas the other option only gets you money, doesn't get me any money, so it doesn't work as a mediation solution. And so I always, always, always want to know and want to think about the business problem. And I think the biggest privilege I have had in working in the line of work that I work in is that I am exposed constantly to different business models all the time. I have to learn my client's business in order to negotiate a deal for them. I have to learn my client's business in order to litigate for them and get them a good result. And it's an incredible privilege. It's better than going to business school. It is something extraordinary that I can't be thankful enough. And so look for a win-win in business disputes. It's always something that you should do in the back of your mind. Sometimes it might not work. Sometimes you think that there is, but the emotions are too strong, and it's not gonna be a go. But that is my go-to. So give me a different perspective. And if nothing else, it give your client additional respect for you. The client will see that you're thinking about it cold-blooded, with a business mind, with a focus on making money and stopping the bleeding of the legal expenses.
Yeah, I really like that with business transactions, that idea and focus that both parties are there to make money, and this dispute with them is preventing that. And in fact, it's, as you said, bleeding both sides. So here, how do we get back to both making money is a really good, excellent tool. How about this? What's a tool that maybe you used to use that you moved away from? Did you learn something new where, hey, this isn't as effective as I thought, and you replaced it?
So I certainly changed the way I do my opening statements. I know
Okay.
that I have moved away. I have changed a lot. So I'll tell you the evolution. At first, when I was a younger lawyer, I would do an opening statement sort of as if I was doing an opening statement at trial. And that, I don't think it was working particularly well for me. It was a good exercise as a young lawyer to anticipate trial, and so it forces you to think about those problems. So that certainly serves a purpose, but I don't think it serves the purpose of mediation, which is we're here to either get a deal done or get a lot more information about why this is not getting resolved, right? Either a deal done or getting a lot more information about why we cannot get this done. And those information will help us sort of move through the next phase, whether that's trial or something else. And at some point, then because it wasn't working, I started believing, opening statements are bad. I shouldn't do opening statements. I should move away entirely from opening statements. I did that for a while. And I read a lot online. I read a lot in my free time. I try not to work on weekends, but it's probably not true, because what I do on weekends is I do a lot of creative work. I do a lot of reading. I do a lot of ideas I think about my business constantly. I think about my profession constantly. But because it's not in a way that I am forced to do it, I am building somebody to do it, it feels very free. It doesn't feel like work. And so I read a lot, and I read a lot about some way more intelligent people than I am, saying you should consider doing an opening, you should adapt it to the different circumstances. And I have changed, and I now do an opening most of the time. It is not the same opening. It will change depending on the psychology of the other side, sometimes the psychology of my client, but I find that the more you give in the psychology of your client at that stage, the less likely you are to get to a resolution in mediation. So that's very dangerous. Sometimes you have to do it because you have to do it, but it will not serve the purpose of getting the case resolved if you give in to the psychology of your client, or really the psychological need of your client. You may be able to understand the need and use it, but if you give in to that need, it might be problematic because they want to see you crushing the other side, and that doesn't do well. And I'll tell you, if you want, I'll tell you what I have started doing the most that I think is incredibly effective.
Please.
Okay. So I don't do it in every case. I don't do it if the other side. There are some cases where we deal with fraudsters. They may not necessarily make sense. But in most every other case, what I'll do at opening is I'll say to the other party, and I'll address them directly by name or by last name, depending, that I am going to do this opening as if they came to me for a second opinion. They went to mediation, the case didn't settle, and now they want to look at somebody, they want to have a second opinion. What's going to happen? Are we going to trial? Am I going to win this case? How does it look like? And so I do that. I do exactly that. I give them a truthful, my opinion, which is a second opinion, because they have already the opinion of their lawyer, about the risk of their case, the good stuff that they have in their case, what it's going to cost them, and whatever the challenges are. If they win, this happens. If they lose, this happens, and why they're worried about it. And it's incredibly powerful because for whatever reason, we tend to not have that conversation with our own client anymore after a while. And because it's an honest conversation, it's an honest assessment of all the things that every competent lawyer can spot. When they go back and they say, was Giacomo right? The other lawyer is forced to say, yes, he was that. I can disagree with the percentages or I can disagree with the risk, but the reality is that they have to say, yes, he is right. Yes, that risk exists. Yes, that thing is true. Yes, if you lose, you can get fees against you. Yes, your homestead is going to be protected, but it's going to make your life miserable for that reason. Or yes, you win a judgment, but it's true that Florida is very protective, and hence you're going to be suffering from limitation on collecting, and it's very painful. It's going to cost you another $100,000, yada, 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 yada. And it gives me credibility. All of a sudden, when then we have a negotiation later on, and you, Patrick, bring back my offer, that offer carries a lot more reputationally. It's easier to believe it for them because it comes from somebody who told them truthful things and made it clear to them what's going to happen next if we don't get it done now.
And so you're not only acknowledging the weakness, because that's what typically people do. You will attack their position, but you're also acknowledging their strengths.
Absolutely. I give them an honest assessment, which is what I do. It's the advantage of doing a lot of what we call intakes at my firm. So I see new clients, if I'm not sort of in a trial week, like this week or next week, or last week, frankly, I normally see an average of maybe 2 new clients a day. And those are 30 minutes meetings in which I receive the information and I have to give an assessment, a strategy, a budget, and a path forward. And I love that. It is my favorite part of the job. It is that quick moving from the client being in distress to the client seeing a path to a solution, and changing their mood, starting the process of feeling better, healing. I love that. But because I do that a lot, it's so easy for me to do it well and honestly in mediation. And so I will acknowledge this is a very good point that I would hammer if I were you. Of course, you have to be, if there is a good point that they have that you don't think they know about, you're not going to give them that. So you're not entirely, you're not open to a fault. But most competent lawyer will know by that point what you know, and you know what they know. And so you don't take a lot of risk by taking this analysis, by doing this assessment. You only gain by giving them this truthful second opinion.
And your intake process sounds like a therapeutic session. Almost like going to a doctor's office. I have this ailment. Here's my problem. I'm in distress, as you said. And you, Dr. Bossa, will then tell them, well, this is what's wrong. These are your options. This is how we can try to fix it. No promises, medical science is not perfect, but we're going to try this. This is what's going to cost you. Would you like to engage in this process?
That's exactly right.
Excellent. I like that. So, before we close out, I want to give the listeners something that they can actually use, let's say on a Monday morning. So, what would be your top 3 tips for better negotiation outcomes? Now, try to be specific, not general things like preparation, but in other words, how do you get people to move?
So I'll give you 3, 2 of which are very specific and easy to action upon. One is a little more vague. So I'll give you the first one, which is very easy. Make sure that your client has food throughout the entire mediation. There is definitive neuroscience on the mistakes we make with our cognitive process and the decision making when we're low on sugar. And people don't think about it. We think about discussing with the client what to wear and why I'm going to do this and why I'm not going to do this and why the other side is terrible and why we're great and why we're going to win and they're not going to win and what this is going to cost and who is Patrick and is Patrick going to be on my side or on their side? Oh, but in Latin America, mediators are corrupt. I'm like, no, don't worry about it. And if we're not talking about, make sure that you have whatever food you really like, a little snack, next to you at all time, and throughout the mediation, you're constantly eating so that your sugar levels are consistent. And I don't want to get you in a position where you're exhausted and you say yes because you're exhausted. It's stupid, simple, but it's life-changing. Have you ever discussed with anybody else, Patrick? Anybody doing this? Have you ever seen anybody doing this or mentioning it?
I've heard that type of advice for depositions, and I've heard that type of advice for those that are attending trial. And I've heard it also for mediation. But I think you're the first one I heard it from that is a lawyer. So I've heard it from mediators suggesting this. And you're spot on. I do a lot of reading just like you, and neuroscience is super important. And so cognitively, you need to be spot on. Mediations can tend to go long. Sometimes people use mediation to do that, to grind you out, just to get you to say yes or no by taking that long time. So yeah, feeding your brain is super important.
I am sure
Well, let's hear 2. I'm looking forward to number 2.
Okay, so number 2 is I believe more in calling mediators than I believe in mediators' statements. So I believe that phone call is more functional, and maybe you can tell by now that my approach is very sort of psychological more than meritocratic, or doesn't go to the merits of the dispute as much. Again, not a general rule, as a guideline. And so I prefer to have that phone call. And it's funny because people at my firm have asked me about it. And they think that I'm calling the mediator so that I can get the mediator on my side. Like, it's funny, and I laugh because it couldn't be further away from the truth. I don't believe in mediator being on either side. I don't kid myself. Good mediators will act exactly the same, and they'll either be very friendly to you and very friendly to the other side, or very nasty to you, very nasty to the other side. But they are very good at being equal to get it done. And they have a reputation to maintain, and we all talk in the community. So it will come out if this mediator was always against me and for whatever reason favoring the other side. It'll become a problem for them. But I believe that phone call is a much better methodology to convey the psychology of the case. Why does this matter to my client truly? Where are the emotional blocks it's hard to put the emotional blocks on a piece of paper. It's hard for me to write that the other side doesn't want to settle because their spouse hates my client, even though their spouse is not a member to this lawsuit. I can't really put it in a piece of paper because you're like, what? What? You have a lot of follow-up questions. So I'd rather call you and say, this is what I think the hurdles are. You go confirm them on your own. You see if they're true. If I'm right that these are hurdles, I think this is a potential solution. You can use it if you think that we're getting there. And so I really use it as a strategy session rather than convincing you that I'm right or wrong. So I'll still have a mediator statement saying, this is why I win the case, this is why, or this is why I lose the case, and this is why I lose only for $1 million, not for 10, like they think. And that's why I'm okay losing $1 million because it doesn't really matter if I do it within a certain time. So I'll give you sort of the strategy part, but I want to have a phone call with you so you can ask me questions. And I can tell you what I think are the blocks to the agreement. That's better over the phone.
Mhm. Very good. I wish more people did that.
Want to know the third one?
Yep.
No. The third one is do as much as you can to understand the psychology of the other party. You're not going to be. That's one advantage of deposition. You get to know them. Normally, you don't get to know the opposing party. You get to know the opposing lawyer, and it's easy to know the psychology of the opposing lawyer. And you need to understand: are they a problem, a roadblock to mediation, or are they an ally that they want to get to the same result? So you want to understand that. But the opposing party is blocked for me as a lawyer, so I can only get their view from my client, but my client's view is going to be biased or prejudiced, right? Could be biased in favor or prejudice against the other side, but it's not going to be neutral. And so one challenge of doing mediation without having taken the depot is that you haven't had a chance to look at them, to talk to them, to interact with them, to see and feel how they act in a high stake environment. People tend to be it's easier to read them in a high stake environment that at a normal dinner, because it's harder to fake it in a high stake environment. Or if you're faking it, you're faking it very sort of intensely, and that is a telling sign of your personality. And so I think know the psychology of the other side, not just the lawyer, because you want to take that into account in your opening, the way you're going to make moves, the information you're going to give to the mediator.
Very good. And since you stated earlier that you do a lot of reading, is there a particular book that has taught you some of these ideas to psychology and how you applied them to law and negotiation? What would
Sure.
be the one that you think is the best?
I'll give you two, right? One is Never Split the Difference. I think you and I talked about it before. And of course, somebody should write Never Split the Difference with a mediator in the middle, because a lot about Never Split the Difference, which is a book by Chris Voss, who's an ex-hostage negotiator, and he's entirely psychological, right? His whole book is about psychology, and he makes the point that he went to Harvard, ran his techniques against his super bright students who were taking this class and negotiating, and they knew the merits of the case much better than him. He would just completely annihilate them constantly, because at the end of the day, it's a psychological game. But somebody should write it about how do I then effectuate those techniques, not through myself, but I have to arm the mediator to then use the technique with the other side. It's fascinating to think about it as a theoretical problem. And then the other book is Thinking Fast and Slow, which I think is sort of the pillar of
That's Daniel Kahneman, correct?
Yes, sir.
Yeah.
Yes.
Well, we seem to have some common books in that we've read.
I'm not surprised.
Very good. Excellent. All right. And actually, given this, those are really gold. But let me ask you one bonus question. What do you think mediators most often get wrong in cases like the ones you handle?
They stop trying too quickly. That's my biggest sort of complaint. I have had some mediators say, "There's no way, it's too far." I'm like, I've been in cases where we're so far apart that you couldn't believe it. We settled by the end of it. So I don't want to hear it. I don't want to hear it. I don't want to hear it unless we're really all exhausted and really physically can't do it. I think that time and pushing more gets you there. And so I'm not thrilled when mediators give up a little too early and not all of them and not all the time, but that is one thing that has happened more than once that I've been frustrated with.
I love that. So, what is never quit in Latin or Italian?
Non mollare mai in Italian. In Latin, I wouldn't know.
All right.
I went to the scientific high school.
Okay. Very good. I love it. All right. Well, this has been a fantastic conversation, Giacomo. I love it. And before I let you go, thank you. And you showed up generously with your time. And I think you really did give the audience something that they can actually take with them, which is the whole point of this show. So, for lawyers, mediators, clients who want to follow you, follow your work, or reach out, where's the best place to find you?
LinkedIn. We're very active as a firm on LinkedIn. We have an active Instagram account, but I think the LinkedIn one is more meaningful. And I think that certainly is a place where I like to engage at times with people. And I find that there's a wealth of resources and discussions that are informative and make you a better professional.
All right. So, LinkedIn under your name.
Yes, sir.
All right. Very good. Well, if you enjoyed this episode, please hit follow on Spotify, Apple Podcasts, or wherever you listen. And again, if you're watching on YouTube, go ahead and subscribe and drop a comment. This has been the Meaningful Mediation Podcast, and we'll see you on the next episode.
Thank you, Patrick.
We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.